you'll recall when we spoke, those who were here last year will recall that when we were speaking with you in August, we were waiting on the court's decision on a motion to dismiss. So a motion to dismiss is the motion the defendants file when they argue in an antitrust suit that you haven't pled enough facts to plausibly suggest that they had an agreement amongst themselves to collude to depress prices. In this case, it's to depress prices. Obviously, in other cases, it might be to increase the price they're charging to the customers. We unfortunately, the judge agreed with them at that stage. The judge basically found two faults with the complaint that we had previously filed. One, he wanted more details about the witnesses that we include in our complaint, who they worked for, who they spoke to, basically a basis for the knowledge that they exerted. And the second was the judge agreed with the defendants, we thought somewhat unfairly, but be that as may, that the prior complaint relied too much on USDA data to support the allegations in the complaint regarding when each defendant reduced the volume of cattle that they were purchasing and the rate at which they were slaughtering them in order to put pressure on cattle sellers. As you might recall, one of the key allegations in the suit is that defendants use their role as sort of the market gatekeepers to put pressure on prices by basically slowing the amount of cattle getting through that gate, particularly the cattle from the cash market, quite effectively during the period that the claim relates, which is sort of 15. You'll all recall that terrible price crash, and sort of going right through to today's date. So we did a lot of things. We were given 90 days to file that amended complaint. We addressed, we added the extra detail regarding the witnesses that the judge requested. So we effectively named the witnesses. We gave them their first and last, their first name and their last initial, and we disclosed the full name to the defendants. We provided details about the people they spoke to and when those conversations occurred, and that's what we did on the witness front. And on the data front, what we did is we went away and we found sources of each defendant's own specific cattle purchases and slaughter volumes, and added a lot of expert analysis of that. Some of that data we had got from the defendants on the limited amount of disclosure that we had been given in this case so far. The court had ordered the defendants to give to us everything they've given to the DOJ so far. That data related to sort of 2019 and early 2020. We were also able to do some economics and some math using the defendants' disclosures of their beef revenues to reverse engineer and estimate credibly the amount of cattle they were each slaughtering every quarter. And finally, we've licensed, we retained certain cattle sales data from people within the industry who were selling to the defendants. So we included an analysis of that. And those were the major additions to the complaint, but which still maintained the essential allegations that the four defendants agreed with each other to take various actions to suppress cattle prices from 15 onwards. So we filed that on December 28th of 2020, a very fun holiday period for us all. And then what happened after that is that the defendants, unsurprisingly, brought another motion to dismiss, arguing that notwithstanding all the additional facts that we have added, that we still have not plausibly alleged that they had an agreement amongst themselves. We obviously opposed that. the judge heard an oral argument on that in July, and we're presently, much as we were last year, awaiting his decision. It's fair to say that we remain, quietly confident that, we think the judge should reject the defendant's motion and the matter, should roll forward. But in the meantime, we're just waiting for the court's decision there to get the nod. Without going into too much detail, Judge Thunheim, who is the judge in this case, doesn't give too much away from the bench. He only asks one or two questions of either side. They're very difficult to get a hard read on what he was thinking from the hearing. But based on some of his other judgments, including a recent judgment he gave in the pork antitrust matter, we feel we're on the right side of this one. But so we're all waiting hopefully on that. If we can kick to the next slide, please. You might recall this, and I'm not going to belabor it. This is the basic timeline of a federal court class claim, which is what this is. Assuming the judge rejects the motion to dismiss, what's going to happen next is that the parties will enter, full discovery. So we will ask of the defendants for them to produce various documents and data relevant to our claims, and they will ask of us, of the plaintiffs, documents and data that our plaintiffs have, that RCAP has, that the other plaintiffs have, that support the claims. And then there'll be depositions of key witnesses. Both parties will ask each other lots of questions, and this process will roll on for about a year. Then what will happen after that is that there'll be sort of two key applications. The first will be by us for class certification. That's basically a request by us to the court to confirm that this is a case suitable for class treatment as opposed to individual suits. And the key issue there is, have we enough evidence to show that the loss incurred by fed cattle sellers is sufficiently similar that it can be dealt with on a class-wide basis, or does it require lots of individualized inquiries? The other application that will come out of all of this is the defendants will almost certainly move for summary judgment, which basically requires them to show that no reasonable jury could find for us. Assuming we pass class certification and the court denies summary judgment, what happens then is that the parties basically head to trial, and there's various stepping points on the way to that, but that's basically it. From the motion to dismiss, if the matter was still to go to trial, I would estimate that's sort of 2 to 3 years away. It could be faster, but equally it could be slower. These large actions unfortunately take some time. Eric, can we kick to the next one? Just wanted to pause briefly to remind people about what you need to do if you want to participate in the class. So the first thing to remember is the American class action regime is an opt-out as opposed to what's called an opt-in class action. So basically, everybody who sold fed cattle to one of the defendants from January 15 onwards is automatically a member of the class. Should the class get certified, or should we reach a settlement, those class members will then get notified and they'll have an opportunity to opt out. Similarly, if there's a settlement or we reach a judgment, you have a chance to opt out, or if you want to participate, at that point, you'll provide some details of the sales you made to the defendants so that your share of the recovery can be calculated. So the main things for you to be doing now is to make sure you're not deleting the records of your fed cattle sales and or of your CME cattle transactions, because those are the types of information we'll likely require to get a sense of what your share of the recovery was, if we're that lucky. And then the other thing is, if you feel you have any information that might be relevant, you see anything that strikes you as strange, pick up the phone to Bill, and he can put you in touch with us, and we'd be delighted to hear from you. Equally, if after today or at any other point you have any questions about what's happening in the case, how it works, or anything else, I'm very happy to speak to you. Again, just pick up the phone to Bill and we'll happily chat it through. All right, next slide, please. Okay, so as I'm sure everyone is sort of aware, there's sort of two government investigations happening at the moment three really, in the cattle market. You have the ongoing DOJ investigation, you have a parallel investigation by certain state attorneys general, and you also have the USDA investigation stemming out of the Holcomb fire and also COVID. As far as we know, and we don't have a direct pipeline to all things that each of them are doing, as you might imagine. All of these government agencies are relatively tight-lipped about where they are. Is that all of their investigations are ongoing. They continue to look at it. They certainly haven't dropped any of the allegations. I know that the DOJ and the state attorneys general have still been active this year out in the field, speaking to folk they believe have relevant information. And I know that the USDA is still working on the sort of follow-up to their initial market context report that they gave in relation to the Holcomb fire and COVID, which was obviously disappointing in the fact that it described events from a very bland portion without describing what any given packer did or didn't do right in relation to that. We're still quietly hoping that, given the time they're taking on the report, that the next report will be a far more exhaustive look at any potential wrongdoing. So they're all in the wait and see bracket. The one important thing to note is, even if it's progressing slower than people would like, what is important is that they haven't closed the investigations. And we can surmise that they haven't closed the investigations because what typically happens when they do that is they will send the companies that were under investigation a letter telling them that they've closed it. And you can, sure as night follows day, the first thing that happens is that the recipients of those letters put out a press release, noting all their shareholders that the investigation has been dropped. We haven't seen any of those, and certainly the other thing they do is that they will email any civil plaintiffs suing them, telling them that this has happened. So the investigations continue, and we continue to hope for a good outcome there. Next slide. So the other thing worth touching upon, and I'm sure we've all seen it, is the criminal prosecutions in the broilers market. What you have there is, and I'm not sure if we spoke about this last year, so apologies to the extent that I'm duplicating. So the DOJ indictments in broilers relate to bid rigging and price fixing amongst the broiler chicken manufacturers in terms of the prices that they were offering to their purchasers. That's an investigation the DOJ had started before their beef investigation. And it's an investigation on which Tyson evidently some time ago applied to be the immunity applicant, which basically means that it fessed up that it had engaged in some anti-competitive conduct and agreed to provide information to the DOJ in return for immunity from fines and criminal prosecution. Since then, the DOJ has indicted Pilgrim's Pride and Koch Foods. Pilgrim Pride paid $107 million for their misdeeds. And the DOJ has also indicted various Pilgrim Pride executives, some Koch Foods executives, I think, as well. And those directors are, and that case is proceeding in Colorado, and those folk are fighting it. Based off the limited access to the materials that we've seen publicly, I think the DOJ has a very good chance of success there. Similarly, there's been some movement on the other related ag cases. Eric, if we can jump to the next slide. And worth just touching on the, before we get into this, obviously in the national conversation, there is a lot of time in the media amongst politicians and everybody else talking about, tech concerns, for antitrust concerns in tech. And that's obviously one big focus. But I think another really big focus that a lot of people are coming around to is the various antitrust and consolidation issues in ag. And I know that you are all painfully aware of these. I know Diana Moss has been speaking to you all about them for a long time. But I think that there is our sense is, amongst politicians too, that this is something that's getting a much closer look, and it's going to be occupying a lot of Congress's time, and it's going to be occupying, I think, a lot of various state legislators' time too going forward. So I think it's it reflects the good work that organisations like yourself and others have done, highlighting the impact of this concentration and other anti-competitive issues have on producers and also on customers, the people who buy the products, and the way in which concentration and the vertical integration has really squeezed people at either ends. And in this very sort of partisan times that we're all living in, concentration in ag is one thing. Particularly, the concentration issues in cattle is one thing that both sides of the aisle, really agree on. So I hold, some perhaps optimistically, a lot of hope that a lot of progress can be made here. So I would certainly encourage everyone to keep, writing letters to their representatives, being engaged in these issues, because I think that, as both sides of the aisle try to reach some bipartisan solutions, this is an issue that they can all agree on, more or less, or at least certain parts that both parties can. So, I think, as Bill has said in many contexts, this is a good time to keep pushing these issues. But in the litigation space, that same attention to these issues has resulted in, a reasonable amount of litigation. So, related to the government investigations, there is civil litigation by purchasers of broiler chickens at various levels. Those litigations, it often happens once the government starts bringing indictments, have started to settle. Pilgrim's Pride, has paid out a fair amount, over 100 million to direct and indirect. Tyson's paid over 100 million, and some of the smaller entities have also paid money. There was also a very promising decision, I think, in the Western District of Virginia, which found that Tyson had breached the Packers and Stockyard Act, sort of on a monopolization style theory, in terms of the way in which it treated the contract growers under its awful flock growing contracts that pit them against each other and basically ensure that these growers, take a loan out, backed by government money to invest capital money so Tyson doesn't have to, and then Tyson throws them under the bus 5 years later. So that was a really good precedent, and I think off the back of that, you've seen a lot of other cases filed by growers in other areas. So hopefully that gets some traction and keeps going. The pork civil antitrust case, that case is before our judge, Judge Thunheim. The key allegation there is that the processes, and remember, pork's a bit different to cattle, as you all know too well. A lot of the processors have their big sow herds and own a lot of their own hogs. Is that they all reduce their sow herds from sort of 10 to 14, 2010 to 2014, in an attempt to reduce production. That reduction in production obviously impacted prices. With the result, the pork purchasers paid more. Judge Thunheim dismissed the defendant's second motion to dismiss in that case, I think late last year, and since then Smithfield has settled with the direct purchasers for about 80 million, and JBS has settled for around 60 million, and the case has continued. There's also been litigation on behalf of peanut producers against Golden Peanut, Birdsong, and Olam. Those have sort of settled collectively for about 130 million, I think. The time for claiming on those, I think, may have passed. But if you know anyone who is a peanut grower, I'd certainly encourage them to Google the peanut civil litigation case and double check that they're putting their claim in for their money. They should have also received a notice in the mail or via email. There is also a relatively new case regarding crop inputs, which relates to some of the chemicals that the Monsantos and Bayers of the world sell to protect crops, pesticides and whatnot. That case is in its infancy. Unfortunately, it got transferred to a judge who is, I understand, less favourable to the class actions, so that's unfortunate. But it's running on, and to the extent that looks like it's going to progress, we'll certainly let Bill know so that he can let members know so that those who are affected can follow it through.